built our firm around one idea: to lead our clients from where they are to where they want to be. But the ability to deliver the leadership and service our clients deserve doesn't happen by chance. It's a product of who we are. We are engaged, diverse, and innovative thinkers who go above and beyond what is expected because we know our efforts will carry us to achievements others never thought possible. We are unafraid to take the necessary risks that lead to new successes. We embrace change because we know sound principles will guide us through new opportunities. We are committed to empowering our people, our clients, and our communities to become every part of what they aspire to be. We are persistent on our journey forward. It is our openness to collaboration, our desire to achieve better, our character, our vision, and most of all, our people that make us who we are. That's the HB difference. We are Husch Blackwell.
All right. Welcome, everybody. Good afternoon. I am Mike Fielding. I am a partner in the Food and Agribusiness Unit of Husch Blackwell in our Kansas City office, and I want to welcome you today to our presentation about maximizing your recovery, creditor strategies for small business bankruptcies. Joining me on the webinar today is my colleague Yana Vladimirova, who's an attorney in Wisconsin. She's a Subchapter 5 trustee. She also focuses her practice doing distressed debt work as well. And we frankly hope we have a lot of helpful and useful insight to share with you today. I have a few housekeeping matters that we need to cover before we dive into the presentation. So if you bear with me, I'll read through these items. At the bottom of your audience console, there are multiple application icons for your use today. If you have any questions during the webcast, please submit them via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or if we run out of time, we will answer it later on via email. A PDF presentation is available in the resources folder. This program has been approved for legal education hours. To report your hours, you will need to click on the CEU icon at the bottom of the screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Now, toward the end of the program, be sure to complete our short survey. We use your feedback to plan our future programs that are applicable to your business needs, and I'll say in part, this presentation today is a direct result of some of the feedback we've received from some of the past webinars that we've done, and there's certainly been an interest by folks out there to learn more about small business bankruptcies. Let's get started with the presentation. I should say one other thing parenthetically as well. I've been doing these webinars on roughly a quarterly basis, sometimes a little bit more frequently. The goal here is to address distressed debt issues from a wide variety of angles. Coming up on August 17th, if you're interested, I'm going to be doing a presentation with Robert Malam of Summit Investment, and we're going to be talking about selling distressed debt loans. That's an issue that's kind of interesting when you look into profitability, bank profitability, and modeling, and how do you go about doing it. We're going to explore those issues and talk about the ins and outs of when you've got a bad loan and you want to think about maybe just selling it as opposed to trying to work it out. So again, that's August 17th. You can be on the lookout for an email for that. All right, so let's dive into the presentation again. Again, I'm Mike Fielding, and Yana Vladimirova is joining me as well. And to introduce today's topic, I want to share a very embarrassing experience that I had last week, and it deals with plumbing. And you'll see why this has to do with bankruptcy in a second. So I don't know, maybe 6 months ago, 8 months ago, our shower, the bottom upstairs cracked and it started leaking. And we needed to replace the shower. So being the cheapie that I am, I went ahead and took out the old shower, put in a new shower pan, thought I had done it correctly, and then we had a friend of mine who does tile. He came in and tiled up our bathroom. Fast forward to about a month ago, and in our dining room, we started looking up and noticed a black spot on our ceiling. And that was not a good sign because it was the sign of mold. Well, like someone with cancer does, you just kind of ignore it for a while, which is what I did, which was, again, foolish. And then last week, my daughter's down there eating breakfast, and it just all starts coming down. Well, it turns out that installation that I did was bad, and there was leakage. And so now if you go into my kitchen, above the dining room table, there's a hole about the size of a Frisbee. And in talking with the plumber last week, we've realized we now have to take that shower pan out, which is going to mess up all the tile that we put in. Now, why am I going on about this point? Well, it's to teach a principle or an example, and that is when it comes to the do-it-yourself stuff, virtually everything I did was correct, but there was that one key issue, connecting the shower pan to the drain where I messed up. And frankly, over time, it didn't have any problems, but then there was an error, and that error ended up being pretty big, and there's big ramifications from it. So it's that small little key issue that has dramatic effects on the outcome. And in my case, it's a hard learning experience, right? It's why I'm a lawyer, not a plumber. That's just not my specialty. So with that principle in mind, last September, Yana and I did a presentation on Subchapter 5 of the Bankruptcy Code. These are the small business bankruptcy filings. Yana has a lot of experience. She's a Subchapter 5 trustee. I've dealt with several of these cases as well. And what's happening is, given a year or passage of time, Yana and I have identified several key issues that can really make or break a Chapter 5 case. Now, admittedly, like any plumbing job that you're dealing with, each situation is unique. And so what we're going to do today is really give you kind of a hands-on guide or application as to things that you could potentially do along the way to try to maximize your recovery. Now, some of the things we're going to talk about will apply in some instances, sometimes it won't. And our goal here is to empower and to educate you so that when you get into the right situation, you can figure out, is this something that you can, the DIY, do it yourself, or is this something where you really need to get a professional involved, like I should have done, which is a plumber, to really get that critical juncture done just right to save you from problems. So the way we're going to do this is, as you can see here on the agenda, there's really a three-part agenda, and Yana and I will jump back and forth. But the first thing we'll talk about is stuff you should be doing before bankruptcy. And I know just like it's human nature to procrastinate, to not think about a problem until it's on you. But the key thing here is, if you are trying to lay the groundwork for a successful resolution in a bankruptcy proceeding, you want to try to do as many things before bankruptcy as possible, because that's going to set you up for a better position. The next key aspect is the beginning of the case, some critical items that you should do right after the case is filed. And then the third big area is when you get into the plan confirmation stage. So with that very long-winded introduction, Yana, let's take it over, and you can start telling us about pre-bankruptcy items.
Thank you, Michael, and hello, everyone. So we're going to start with what creditors should be aware of prior to a Subchapter 5 being filed, and specifically what makes a Subchapter 5 case different than a regular Chapter 11. As a way of background, the Small Business Reorganization Act, which was enacted approximately 2 years ago now, and what made Subchapter 5s possible, aimed at addressing a longstanding problem with small businesses, which in the past not only did not succeed in Chapter 11s, but didn't file them altogether. And this is because, given the relatively simple capital structure of most small businesses, filing a Chapter 11 was expensive, and oftentimes it resulted in a loss of ownership by the very shareholders or interest holders who had often founded the company and managing the company. And the reason for this result was what is known as the absolute priority rule. which in essence provides that if equity holders do not pay their debts in full, they cannot retain ownership in the business. The Subchapter 5 fixes that problem, which is one of its main benefits for debtors, but it's also one of the main problems creditors have with Subchapter 5 cases. So another difference for Subchapter 5s in comparison to regular Chapter 11s is that a plan can be confirmed even if all classes of creditors reject it. Again, this is quite different than regular Chapter 11 that requires creditor support. And Michael and I are going to talk more about this later, but in a Subchapter 5 case, there are two ways to confirm a plan. A plan can be confirmed consensually and non-consensually, and there are benefits for confirming a plan consensually, but again, there's no requirement that any creditor consents to it. Another difference in comparison to regular Chapter 11s is that administrative expense claims can be paid throughout the plan, not at confirmation as a regular Chapter 11. As I said already, the absolute priority rule does not apply, and the debtor needs to only pay disposable income for 3 to 5 years, and the court can confirm a plan if it finds that the plan provides for fair and equal treatment of similarly situated creditors. If a plan is consensual, meaning all creditors support it, the debtor gets a discharge upon confirmation. If the plan is not consensual, which can mean that no creditor supports it, and payments are made for 3 to 5 years, the debtor will get a discharge once all payments have been made. And again, because of the lack of the absolute priority rule, the debtor retains ownership of the assets. And Michael will continue with are your loan documents in order?
So one key thing I want to just add on to touch on what Yana said, and this is kind of the quick and dirty takeaway. Subchapter 5 makes it a lot easier for debtors to confirm plans to the detriment of secured creditors. And when you're in a traditional Chapter 11, a secured creditor, frankly, has a little bit more leverage. And so it's critical when you get into the Subchapter 5 context that you really know where your leverage points are and really act in a way to maximize the situation to get the best benefit for yourself. And so the first place we begin with doing that is if you're a secured creditor, and again, this is before the bankruptcy is filed, is you need to have a really good handle on your loan documents. The questions I have here, they're the basics, right? Are your loan documents in order? Are your UCCs filed? Are your mortgages recorded? Do your loan documents appropriately reference one another? That seems like a very basic question. That's kind of like 101 for distressed loan workouts, because if you have errors in your loan documents and you go into a bankruptcy proceeding, once that petition is filed, you may not be able to cure some of the problems, especially if you didn't properly perfect. And so when you catch wind that your borrower is maybe on the verge of a bankruptcy, thinking about bankruptcy, you want to quickly jump through those loan documents, look for errors. And if you find an error, you need to scramble. You need to try to, A, cure the problem, but then B, if you're the secured lender, typically if you're the secured lender, that means you're typically going to be the big behemoth to the debtor. And that means you need to move or work with them in a way that postpones the bankruptcy, that gives you the time to cure the defect in your loan documents so that if they do eventually file, you'll be protected. Now, one obviously way to do that or related to that is you get into the forbearance agreement. When you look at the continuum, the timeline of a typical distressed loan, you go through this period of, well, can they refinance? And then they don't do that. And the loan continues to deteriorate. And at some point, it's a problem loan on your books and you have to do something about that. So you move into a forbearance agreement situation. And when you are crafting the forbearance agreement, obviously the goal, the hope is that things work out. And quite frankly, it does a lot of times. But there are definitely situations where the forbearance agreement doesn't work out. And so what you want to be doing is, working towards a resolution in the present, but simultaneously be planning for a disaster in the future. And the way you do that, one of the ways is when you are going through your recitals in your forbearance agreement, it's really important that you craft a lot of whereas clauses, whereas we made the loan on this date, whereas there was this default, whereas this much is owed, whereas this is the value of the collateral or the approximate value. And you get all those different items, and then you have a line in there where the borrower says, all of these statements are true. Now, the reason that's important is because if you get into either a litigation scenario or if you're running into bankruptcy, you want to have something that's going to be admissible against the debtor that you can wave in front of a judge and say, look, they already admitted this. They already have these problems, and you want to use that as an evidentiary basis to get whatever relief you're trying to seek. So that's the first beginning point. Now, another option that you should consider in your forbearance agreement is consider building in language that the debtor will agree to or not oppose a motion for relief from the automatic stay if they file for bankruptcy. Now, I'll admit there are some courts that find that those provisions are unenforceable, but there's also several other cases out there where they find that those provisions are enforceable. And at a very minimum, it creates a presumption that the debtor agreed to it. And it may be that you'll give them this period of time to work things out, but if they file, you at least want to have this argument that they've agreed to grant you stay relief so you can go ahead and foreclose and liquidate the collateral. Because, at the end of the day, banks are biased towards liquidation. That's what we want, right? We don't want to deal with a bad loan stretched out over a long period of time. We want to have a performing loan. We want to have that capital being employed so it's profitable for the lender. And again, we're looking for different ways or means to try to maximize that. Now, another unique item or unique way to proceed with this is in your forbearance agreement, get them to agree not to elect to do the Subchapter 5. It's an interesting issue. I'm not aware of any case law on that, but if they did make that election, you could then go into the court and argue that they waived the right, that this designation was erroneous, and that it should be reclassified as a traditional Chapter 11, which they can do that. That, again, is giving you as a lender leverage over the situation. We want to try to control and posture this as good as possible to put us as the lenders, the creditors, in the best position. Another unique item is this idea of a springing guarantee. Now, guarantees are kind of the backbone of commercial lending. It's almost, commercial lending malpractice not to get a guarantee. I shouldn't say malpractice because that's not the right word, but, that happens almost all the time. But one of the options is get a springing guarantee where you say this guarantee only becomes effective if the debtor files for bankruptcy. And you may want to get that. Maybe you did a non-recourse loan, and maybe you're trying to put some pressure on the borrower, or maybe he has an affiliated company. A springing guarantee that's tied to the filing would be one way to create that strong disincentive or a disincentive so they don't file for bankruptcy. Now, another item of concern or something to be thinking about is in the context of a prepackaged Chapter 11. And what do I mean by that? Well, it's done a lot, especially in the big cases. If you go down to Texas in the past 12 months, there have been a large number of these oil and gas, prepackaged bankruptcy. And all a prepackaged bankruptcy is prior to the filing of the case, the debtor comes up with a proposed plan. They file for bankruptcy, they file their plan, and they get it confirmed just as quick as they can. That same principle can be applied in a small Subchapter 5 case. Now, if you're the lender, why would you want to do that? Well, I'll tell you a really good reason. If your borrower has a lot of unsecured debt and you are trying to, make the loan better performing, quite candidly, a bankruptcy may be a really good thing because they could file for bankruptcy, discharge a lot of that unsecured debt, and then emerge with the capability to service the secured debt going forward. Frankly, they could probably improve the loan to value ratio, maybe not the loan to value ratio, debt to equity ratio, by getting rid of some of that debt. So that's something to be considering. Again, that works if you have sufficient equity and you're looking on a cash flow basis. How can we make this debtor perform? The other items that you will want to be thinking about are debtor in possession financing and use of cash collateral. We'll be talking about those in a few minutes, so I'm not going to belabor them here. But here's one key point. When you are negotiating the financing with your borrower, you got to recognize that there's the borrower and then there's the borrower's counsel. And guess what? The borrower's counsel is representing the borrower, but the borrower's counsel is self-interested as well. And so one way, and this sounds almost bad to say this, but it is human nature, is if you're looking for key concessions, what you may agree to do as the lender is say, hey, we're willing to give you a carve out for some sort of, like $25,000 or whatever the number is for attorney's fees. And in exchange, we want, A, B, C, D, E, all these different concessions. Well, the problem is you may get a attorney who says, well, okay, I can get that through. And he's essentially, he or she may be selling out their client, so to speak, so that they can get their own attorney's fees preserved. But what the critical thing there is you as the lender get really critical concessions that can have a huge impact on the ultimate end of the case. So you want to, again, be thinking through these items. It's like, how do we, going back to my plumbing analogy, how do we tighten that so it's on tight so that it works for us down the road when you get stress going on? All right, Yana, tell us about part 2.
Okay, so now that the case has been filed and you as a creditor determine that Subchapter 5 is not beneficial to you, the first thing to do is to see if you can challenge the debtor's eligibility to file under Subchapter 5, because not every business qualifies for that election. First of all, to be able to file under Subchapter 5, the debtor has to be engaged in commercial or business activity. So while an individual can file under Subchapter 5, that individual has to have a business to reorganize. Next, the aggregate non-contingent liquidated debts cannot exceed more than 7.5 million currently. Originally, when the Small Business Reorganization Act was enacted, the debt limit was only 2.7 million. And then a few months later, the pandemic started. And for those who remember, the CARES Act was quickly enacted, and that increased the debt limit to 7.5 million. That increase was set to expire this past spring, but it was continued. So it isn't clear at this point whether it's going to remain this way, but from what I've seen, it does make a difference. Having the debt limit up to 7.5 million allows a lot more debtors to elect to file on the Subchapter 5. Also, 50% of the debt. And also of the 7.5 million cap, that cap excludes debt that's owed to affiliates or insiders. So we are just talking strictly debt owed to outside creditors. Also, 50% of the debt must arise from commercial or business activities. So the debtor cannot be an individual whose main reason for filing is not related to a business or some other commercial activity. And finally, a debtor cannot elect to file under Subchapter 5 if the only asset the debtor has is a single real estate. Under the code, a single asset real estate means basically real property constituting a single property or project other than residential real property with fewer than 4 residential units. Which generates essentially all of the gross income of a debtor who is not a family farmer and on which no substantial business is being conducted by a debtor other than the business of operating the real property. So I'm aware of at least one recent case from Florida, which has held that, for example, a hotel is excepted from this definition. I know that there are other courts which have held differently because with this requirement, the first thing that comes to mind is really, can a hotel file under Subchapter 5? And this Florida case held that it can, because it, in addition to managing the hotel, hotel also provides parking, pays for cleaning. And so that court considered these activities to be separate from the single real estate. Again, I've seen other cases that have gone the other way. So this is, I guess, an issue that will need to be played out by the courts. So another thing, so let's say that you cannot challenge, there's nothing you can do to challenge the eligibility of a debtor to file under Subchapter 5. There are two more things you can do prior to confirmation. If there is gross mismanagement or even the evidence of fraud, you can move to remove the debtors that are in possession, which means that the management of the company will be removed from running the business and replace that management with the Subchapter 5 trustee. And I actually currently have a case where that's exactly what happened. So I'm currently operating the business. Of course, the trustee will hire management and professionals to operate the business. But if you have the correct facts for something like this, this is a remedy that creditors can utilize. Another one is to, again, if there is the presence of mismanagement or there is actually a long list of what constitutes cause for seeking to dismiss the case or convert it to our case under Chapter 7, which is basically a liquidation, you can try that avenue as well if you think that you will fare better as a creditor under liquidation or outside of bankruptcy, where you won't be prevented by the automatic stay to pursue state court remedies.
All right, so one of the issues at the beginning of the case is, what are you going to do with the cash? Really big, with the old, was it deep throat from Watergate, follow the money, and this is where you really want to pay attention to what's happening here. One of the first questions you need to ask is there going to be any post-petition lending that occurs? I actually was involved in a presentation earlier this year where we went in depth on debtor in possession financing, but from a bank's perspective, debtor in possession financing actually can be pretty lucrative because you get higher rates, can charge higher fees, but the caveat is you're loaning to a debtor. So you want to make sure there's sufficient, hard equity, or hard collateral there that can back it up. And so one of the ways you can do that is potentially get a lien on new collateral, new assets that are out there. Maybe there's unencumbered property. That might be a way to do it. If you are, say you are the pre-petition lender and you don't want to lend to the debtor post-petition, you need to be careful about if they try to pull in some new lender who may try to get a priming lien. The bankruptcy code does allow for that. I'll give you an example. Let's say that you had a loan of, say, $1.2 million and you have real estate that's worth $2.5 million. So very, equity rich property right there, and say they wanted to do a debtor in possession financing loan of $500,000. In that type of scenario, you as the lender would be, frankly, would be a pretty strong argument that you could be primed and be put into a second position because there's such a huge equity position in the real estate. So again, you really want to watch that if somebody's going to come in, and obviously you would object if need be. Now, a lot of times, there isn't debtor in possession financing, but you get into the issue of use of cash collateral, which is really big for a bank because, you loan the money, they sell their goods and services, and then what? The bank has a lien in AR. Well, the problem that you have is that post-petition, your lien doesn't extend to new assets that are generated post-petition. So while it's true that the bank's lien in the AR extends to that AR, if they're doing new sales going forward, you may not have a lien in that AR. And obviously, if you're wanting to use cash collateral and keep the company operating, you want to, maintain your lien position. So the way that is typically dealt with is a cash collateral order where the bank is given a replacement lien for the use of the assets. Now, it's really critical that if you're getting into that you have a tight budget, that you really monitor the debtor, that you really are vigilant to make sure that they're doing what they say, and you want to build into that cash collateral order protection so that you can get automatic relief from the stay if you need to shut things down. The other really big issue when you're dealing with the cash is you want to lay the groundwork for a successful plan confirmation. So in my perfect world, if I'm wrestling with these issues, if I'm dealing with either a debtor in possession loan or even the cash collateral, I'd want to try to craft that order in such a way over here that when we go down the timeline, down to plan confirmation, that these provisions and these benefits that help me as a secured lender, that they're incorporated into the plan. That makes the plan confirmation process faster, easier, and frankly, cheaper, because we're trying to minimize our expense and maximize our recovery. Yana, what should unsecured creditors do? They don't have the luxury of being secured.
Unsecured creditors are particularly vulnerable in a Subchapter 5 case, and this is because, as I mentioned earlier, the debtor does not need their approval to confirm a plan. Also, regardless how large they are. Also, if the unsecured creditor provides services after the petition date, these services normally they are administrative expense. In a regular Chapter 11, administrative expense will be paid at confirmation. In Subchapter 5, they'll be paid throughout the plan. So if the case is dismissed, those administrative claims are kind of out of luck. So one thing that the unsecured creditors can do, especially if they provide services post-petition, is to put the debtor on cash in advance terms. This eliminates the problem with the administrative claims not being paid post-petition. As in any bankruptcy, unsecured creditors must file proof of claim, and to the extent that it's available to them, assert a 503b9 claim. As a reminder, Section 503b9 provides that a creditor has an administrative priority over unsecured creditors if it provided goods that were received by the debtor within 20 days from before filing the bankruptcy case. In addition, creditors should be prepared to evaluate their preference exposure. For those of you who have not been lucky enough to experience preference claims asserted against them, basically any payments made by the debtor to creditors, to unsecured creditors prior to the bankruptcy filing, could potentially be recovered by the trustee if the trustee can prove that they were not made in the ordinary course. There's a list of exceptions, but just even dealing with this sort of litigation can be quite expensive and frustrating. So it's one thing that unsecured creditors should look into. If an unsecured creditor has a large enough claim, even though technically the debtor can cram that down regardless of the size of the claim, there are reasons why consensual plans are more beneficial to debtors, including, as I mentioned earlier, debtors would get a discharge upon confirmation versus at the end of plan payments. And also, if the plan is consensual, the trustee's duties are terminated upon confirmation, which makes it much cheaper for the debtor to operate, because instead of paying a monthly fee to the trustee to continue making distributions and monitoring the case, the trustee's done. So for that reason, debtors would generally prefer to confirm a consensual plan. So especially if an unsecured creditor has a large enough claim, they would listen. Another thing unsecured creditors can do is seek the appointment of a creditors committee. Creditors committees are rare in Subchapter 5 cases, mainly because of their size and the speed with which everything needs to move. But for unsecured creditors, it can be a great way to have additional negotiation power and the support of other creditors who are similarly situated. And all Sorry. Plan confirmation, part 3. Time is of the essence in subchapter 5 cases. Unlike regular chapter 11s, where the debtor can propose, has the exclusive right to propose a plan within 120 days from filing in a subchapter 5 case, that time frame is reduced to 90 days. And at least in the cases I've been involved in, where debtors have sought to extend that deadline, courts have not been willing to do it, again, citing the idea that subchapter 5 is supposed to be very fast and efficient and cheap. So giving debtors extra time to file plans is it's not favored by the courts. My advice would be to be proactive right away and negotiate early. I would suggest immediately contacting the Subchapter 5 trustee. Subchapter 5 trust is a little different than than trustees in other bankruptcy cases, because their main function is to facilitate a consensual plan of reorganization. So they'll listen to you, and they'll talk to the debtor and try to negotiate a better treatment for your claims to the extent that this is possible. Again, there are reasons why debtors would want a consensual plan, so it's not like you're without remedies just because a debtor can cram down do whatever they want in Subchapter 5. It's important to negotiate both your claim treatment and the overall plan. There are certain provisions in the plan that can be negotiated. For example, plan payments have to be made between 3 and 5 years. So you can try to negotiate for payments being made over 5 years. Discharge, as I said, in a consensual plan is upon confirmation, but I see this more and more that creditors request that this is not what actually happens, and that the debtor receives a discharge at the end of plan payments, which ensures them that they get their plan payments and the debtor doesn't get a discharge right away. So it is important to think about both how your claim is treated and how the overall plan is proposed and what can be done in that context. And again, there are reasons why debtors want a consensual plan. So you can use your negotiation power to extract concessions for supporting a consensual plan.
Right. So now we're going to talk about something that, well, Jana actually touched on it. Is it consensual or not? And this is really important about what I'm about to say, this distinction between Section 1191A and 1191B. We'll go through both these subsections in a second. But the reason this is so critical is because if you can get confirmation under 1191A, which is consensual confirmation, that's going to lock the debtor into place. And the flip side is, if you get confirmation under 1191B, you are in a potential situation where you have a debtor string this bankruptcy out for literally potentially years. If you're dealing with that from a lender's perspective, that's really bad, because you can have a debtor who constantly defaults, maybe is running back to the court to amend their plan. If anyone's had experience in Chapter 13 cases, you know that definitely occurs, where you have somebody, they take forever to confirm a plan, and then they default, and they amend, and they amend, and they amend. It's a very time-consuming and frustrating process. And the neat thing about the Subchapter 5 is it gives us the ability to kind of potentially sidestep that if you can get consensual confirmation. So when you get 1191A plan confirmation, this is where you have consensual confirmation. You don't have any parties opposing the plan. And that's really critical, because a lot of times your unsecured creditor class, if they're getting something, they're going to favor it, right? I think historically, unsecured creditors tend to vote in favor unless they're super big and they think they're getting really ripped off by part of the plan. But if you are the secured lender, it's typically one vote, your vote. And how are you going to vote? And sometimes the debtor may be trying to push some things down that you really don't like, but at the same time, you need to counterbalance that with, well, yeah, this isn't the most palatable thing, but yes, I can swallow it, I can live with it, and it's a lot better than the alternative. So let's go through this list really quick. you get your debtor making the payments, the trustee's service ends. I think the biggest thing with the consensual confirmation is the plan gets locked into place. It's immediate. Once that first payment's done, you get quote unquote substantial consummation. The debtor is then bound by the terms of the plan, and most importantly, the automatic stay terminates. The reason that is significant is because, going back to this Chapter 13 analogy, where maybe the debtor confirms a plan, they go 2 or 3 months making payments, and then they default, and then it takes them 4 or 5 months to try to come up with some fix to their plan. Well, if you're a bank, you don't want to have a non-performing loan for that big period of time. What you would like to do is that if they default in their plan payments, you want to be able to immediately jump in and start your foreclosure process. And that's what you get if they do this 1191A plan confirmation, because the automatic stay is no longer in effect. So you can see that there's some benefit there. You can also get around certain provisions in the bankruptcy code if it's done consensually, where the debtor wouldn't otherwise be able to do it if there was opposition. Now, the flip side is, what if you can't get a consensual plan? Well, this is what happens. You have a trustee in place for 3 to 5 years. That's going to be time and money. The trustee's dispersing the monies. The automatic stay remains in place. From a secured creditor's perspective, that is maybe one of the biggest things that's out there, because if they default, you typically have to send a notice of the cure. You then have to file a motion for stay relief, and you may be looking at like a 60-day period before you would even be able to proceed with a motion for, foreclosure of the property. That's assuming you can get stay relief. So you can see how this can really drag on and not be a good situation for the secured creditor. The other issue is, if you're in this non-consensual situation, the debtor can modify the plan. So if they default, I tried my best, so guess what? I'm going to now do an amendment. Again, you could have this situation where you've got this impaired loan being on your books and just getting, marginal payments dribbled out over some extended period of time. We just don't like that. Again, the big thing here is that this 1191 plan confirmation, the Subchapter 5 allows the court to confirm a plan even if everybody opposes it, all right? Everybody and their dog could vote against this plan, and the court could still confirm it. That's one of the reasons we don't like this from a lender's perspective, is because it gets crammed down us. Now, you have some pushback. The 1111B election. This is a powerful tool for secured lenders. And the way it works is, and I'm going to make up numbers here to articulate the example. Let's say you have real estate that has just a $500,000 value, but let's say your total debt that is secured by that is $1.5 million. Or maybe let's put this in more realistic terms. Let's say instead of real estate, it's a restaurant loan, right? The original loan was $1.5 million. COVID hits. Prices go down on the collateral. So now we've got a restaurant loan. We think the collateral might be worth $500,000, but we know the debt amount is $1.5 million. The benefit, if you get into a bifurcation where the where the debtor does a cram down, they could treat the secured loan at $500,000 and pay interest over some period of time, and then they could treat that $1 million deficiency as an unsecured claim. And you can see how that would not be ideal. But if the creditor invokes the 1111B election, what that means is that the debtor has to pay the full $1.5 million over time, but without interest. So you can see that when you are in a really undersecured situation, making this election can be really powerful, because that increases the nominal dollar amount that the debtor has to pay to the secured lender. It's a really powerful tool. And the question is, when do you use it? Now, obviously, that's going to be dependent on the facts and circumstances of the case, but you want to recognize that if you have that leverage, you can essentially get into a negotiation situation with the debtor, which is, you give me A, B, C, and D concessions, or I'm going to do this, I'm going to invoke this election. And the problem is if you make that invocation of the election, they may not be able to confirm their plan. And that's kind of the ultimate trump card. Are you going to push them into a liquidation? Admittedly, it's a bit of a game of chicken, but maybe the collateral's such that you'd be fine pushing them into a liquidation and getting the collateral. So again, this is a powerful tool that you have in the toolbox that you can potentially use. Now, we need to give this a little bit of a caveat that you can't use the collateral when the value is inconsequential. What do I mean by that? Well, let's say that you had a $1 million loan and it was on AR, and this is really old AR, and maybe you can only get like $30,000 or $40,000 of the AR. Well, you probably run a big risk in that situation that a court would say, yeah, that's only 3 or 4%. That's really inconsequential, and the court wouldn't allow you to invoke it. So it's a powerful remedy, but it's not an unbounded remedy that you can use. Yana, what about disposable income?
So if after all that the debtor proposes a plan you don't like, you're not without remedies. There are certain weapons creditors have to fight plan confirmation, and one of them is disposable income. Remember, debtors have to contribute disposable income from 3 to 5 years. And generally, disposable income means the debtor's current monthly income less reasonably necessary expenses for the support of the debtor and the operations of the debtor's business. This definition is vague enough, and there is almost no case law in Subchapter 5 interpreting its meaning. So for that reason, debtors can play with the numbers pretty easily, from what I can tell. So how is disposable income calculated in reality? You can challenge their revenue projections. If it's not consistent with past revenue, you can point this out to the court. Is there really cash available to pay creditors? Is disposable income dedicated to creditors from 3 to 5 years? The same way you can fight also expenses. What exactly does it mean to have reasonably necessary expenses for 3 to 5 years? Another thing you can fight is the plan's
Yana, before you go on, can I just jump in and make one comment on disposable income? So let's take what Yana said and then just flip it on its head. Now, if folks remember, I talked about a prepackaged Chapter 11 and that there are situations where that might be ideal from a lender's perspective because they can shed unsecured debt. And so typically you think of what Yana was approaching about is where they're really trying to do one over on the creditors and really try to get as much money for the secured creditors. But if you take a little bit different view, if you have a situation where the debtor is going to pay the lender in full and they're just really trying to shore up their finances going forward, this vague disposable income definition can actually be used for those secured lenders' perspective. And what I mean by that is they could say, well, there's this gray area, maybe there's $100,000 of kind of this gray area each month. And is it really necessary or not? Well, you say, yeah, it actually is necessary for the preservation of the debtor's operation. So instead of paying $100,000 to unsecured creditors, maybe we'll just pay $30,000 over some period of time. Well, that means that $70,000 can then be used in the debtor's operations. But the flip side, the domino effect to that, is that means the debtor is going to be in a much stronger position to make its monthly loan payments to its secured lenders. So again, you want to think through this process about how the dominoes play out, and you might be able to use that disposable income definition to your benefit, again, potentially depending on the circumstances of the case. All right, Yana, sorry for that interruption.
No, this is a really good point, and it also goes to visibility, which is just related to what you were just saying. Another way to attack the plan is as a creditor, if you can show that the debtor is not likely to be able to make the payments under the plan and the projections are too optimistic. Again, you'll be looking into past performance, and if the projections are not, have nothing to do with what the debtor was able to achieve in the past, you can challenge this in this way. Going back to disposable income and feasibility, this case where the debtor was removed as debtor in possession and currently operating it, what the debtor tried to do in that case is reduce its revenue. So it stopped signing contracts so it can confirm a plan that was providing for less disposable income. And so so it would look like the disposable income that was available to creditors was not as much. And it was just, the debtor's counsel kept saying things like the debtor doesn't want to work just to pay creditors. So there is a lot that debtors are currently trying to do just because there's not enough case law to interpret what the definition of disposable income and feasibility in Subchapter 5 cases. A plan can also be thought to not be feasible if it does not include appropriate remedies to protect creditors if payments are not made. So if something happens to the debtor and it's not able to generate the monthly income that to pay creditors, a plan will need to provide for some sort of alternative remedy to address that and pay creditors.
All right, so now we get into the best interest of creditors test. And this is another way, if you're fighting tooth and nail, trying to defeat a plan, this is one of your kind of main arrows in your quiver. And in order to confirm a plan, you have to show that the creditors are better off under your plan than if the case were liquidated in a Chapter 11. Now, the way debtors try to get around this, I'll give you an example from it was a Chapter 12 case last year, but it's directly analogous to this situation. The debtors in that case had a very large cattle herd, and they did an incredibly low liquidation value on the cattle if they were to do it. And they said, listen, you're not going to get much if we sell this collateral, so therefore we don't have to pay you much as part of our plan. Well, the problem is, at least last year, the cattle prices were really strong, and that argument really didn't pass muster. And so when you are challenging this, you need to take a good hard look at the collateral and say realistically, what would you be able to get for it in a Chapter 7 liquidation? Now, admittedly, that's going to be at a liquidation fire sale, not as a going concern, and that gets into the give and take. But that actually opens up the door to the bottom bullet point there, which is a 363 sale. So for those that are not familiar with it, a Section 363 sale is a sale in bankruptcy, which is free and clear of liens and encumbrances, with obviously the lender's liens attaching to the proceeds of the collateral. Subchapter 5, admittedly, this doesn't happen very frequently, but Subchapter 5 allows for the wholesale sale of assets. So you can have a Subchapter 5 plan of liquidation. And so given that reality, we know in big bankruptcies, they'll do these 363 sales and sell the business as a going concern to a new company. That same concept can come in and apply to a small business Chapter 5 case. And so when you are attacking it from a legal perspective, you want to say, hey, can we show that we'd actually be better off in Chapter 7? If so, the plan fails. But then B, as part of this give and take of the negotiation, if you can show that you're maximizing value by an immediate sale to a third party as a going concern, that might be a way to push and negotiate to try to maximize value for the creditor body. Again, this is just one of those potential arrows in your quiver. Yana, what about unfair discrimination?
Well, this is just another way you can fight plan confirmation. What this means basically is that the plan does not provide for the same treatment of similarly situated creditors. So, for example, if the plan wants to pay one unsecured creditor in the same class assessed differently than another, this is not allowed because unsecured creditors would need to have the same priority. This, of course, goes to all kinds of creditors. Secured creditors need to have the same priority, and administrative claimants. So if the plan does not do this, this is one way you can fight confirmation. In addition, if the debtor wants to keep a secured creditor's collateral, it has to propose a plan that provides for the payment to secured creditors with interest before unsecured creditors can be paid. And finally, and this is more of a creative argument, if a secured creditor's collateral is something that quickly diminishes in value, for example, accounts receivables, which can become harder and harder to collect over time, or the collateral is inventory, for example, which quickly diminishes in value, a secured creditor may be able to argue to the court that a plan proposing to first pay administrative claimants. Oftentimes, administrative claimants include attorneys being paid before a secured creditor. A secured creditor may be able to argue that the plan discriminates unfairly because what it effectively does is that it turns a secured claim into an unsecured claim if the case is eventually dismissed and the secured creditor's collateral is gone. Mike, do you have anything else to add to that?
No, I think you nailed it right on the head. And so we're getting here towards the tail end. We did have a few questions come in. I know I've answered them individually, but let me just read through a few of these questions that we've had really quick because some of the participants here today asked some good questions. One of the first questions was, asking if this was a byproduct of the CARES Act. And the short answer is this is a really, perfect storm. President Trump signed this Subchapter 5 into law in August of 2019. It became effective in August of 2020. The CARES Act, as Jan indicated, jumped that debt limit up to $7.5 million. And then President Biden signed the extension of that $7.5 million for 1 year. So here's the big question mark for all of us. Assuming that the economy rebounds and does well, which we all hope it does, when you get into, it'll be March 27th of 2022, that $7.5 million debt limit is set to sunset. And if you have small business debtors that are sitting there on the cusp and they're still kind of struggling financially, and if there's not a further extension of that debt limit, then we may see a big uptick in small business bankruptcy filings. We saw this back in 2005 when there were amendments to the bankruptcy code that were much more creditor friendly. And there's certainly the definite possibility we will see that as we get closer to next year. Well, and quite candidly, I think we need to pay attention as to what happens with COVID. One of the other questions that was raised was when you're talking about disposable income and you're dealing with an individual, would the IRS standards for reasonable living expenses be considered? And I think the short answer is yes, that absolutely would be an influential factor that would potentially come into play. So with that, Jana, we don't have any other questions. Do you have any other parting thoughts or comments before we wrap this up today?
Not really. I think you covered it all. It's been a very interesting year as a Subchapter 5 trustee for me, and especially with COVID, we've seen more cases than I think when this law was enacted were anticipated. And it will be very interesting what happens if the debt limit goes back to 0.7 million, because from what I've seen personally, it is mainly utilized by businesses that total debt is higher than 2.7 million. So it's interesting. It will be interesting to see what happens in the next 1 year.
Yeah, and that's my experience as well. You're definitely seeing companies use it right now in that middle range. So, well, folks, thank you again for joining us today. We hope this information's been helpful. You can see Jana's and my contact information there. You'll see the short survey at the end, and if you'd like us to reach out to you to discuss any individual issues that you have, you can leave a note there, and Jana and I will be happy to reach out to you and talk with you. As a reminder, this program has been approved for the legal education hours. To report your hours, you'll need to click on the CEU icon at the bottom of the screen. A certificate of attendance, including, the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for your watching and sharing. Again, we ask you to complete the survey. We really pay attention to that. The feedback we've received in the past has been very helpful, and we definitely look at it in developing future programs. This concludes our webinar today. Thank you and have a good afternoon.